Good morning, all. This case management conference is in the matter of CFI 032-2025 before His Excellency Justice Roger Stewart, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Hamdan Al-Shamsi, lawyer and legal consultants. Lead counsel is Mr. Robert Whitehead. The defendant is represented by Nasser Bijamal Limited. Lead counsel is Mr. Amir Bijamal. Thank you, Your Honor.
Good morning. First of all, thank you very much for agreeing the draft terms of the case management order. I've just got a few questions, unless there's any points that you particularly want to address. You've agreed that there's going to be an amended defence and counterclaim and consequential pleadings. Can you just tell me what the scope of the anticipated amendments is, please?
Shall I start, Your Honor?
Well, if assuming that the amendments originated from you, which I suspect they are, yes, please.
Well, I'll give Your Honor a bit of a background. So, Mr. Whitehead came recently into the case because the claimant had been represented by its director up to that point. So the discussion started because Mr. Whitehead wanted to amend the reply to the counterclaim that we had submitted, and also at the same time we also felt that there was a bit of a confusion during the earlier stage as with regards to the applicable law, because the applicable law under the contract is English law. However, in the earlier submissions, and I think it was due to both parties' confusion on part of both parties, that some pleadings were made on the basis of DIFC law. So in order to rectify this position, we also wanted to amend our pleadings to make sure that everything is consistent with the fact that English law is the substantive applicable law, and therefore we both agreed to amend the pleadings.
Thank you. And so both of you, if I can put it this way, are tidying up your pleadings principally in order to deal with any differences between English law and DIFC law. Is that right?
It's not restricted to that. What we've discussed and agreed is that it will go. Because there are certain arguments that were not advanced by us. Well, not in the. It's about the articulation. So I think the basis remains the same for our counterclaim and defense. However, there are some arguments which were not articulated in a certain way. For example, such as the fact that we are arguing that the other side should not have charged any margin on the prices, and the way we had presented that argument in the beginning was in the form of the claimant having a fiduciary duty towards the defendant acting as the consultant in the contract. And within this context, we now would like to add some other arguments around the same facts, to the effect that there was a duty to obtain best prices possible. That's one example of the kind of repositioning of arguments.
So the answer is that it goes beyond that. But the only reason I'm asking is that I'm a little undisposed to giving permission to appeal in blank, but you've agreed it. I'm inclined to permit it on the basis that if either of you come back and say no, this goes far too far, or the amendment shouldn't be allowed, well, you can or you can make an application. But it sounds to me as if both of you have had a sensible discussion and don't understand there to be any likely problem in relation to that. Is that fair?
Yes, I mean, we have
If I can, yeah, I've not had a chance to to articulate my position. So just, and again, Mr. Bajmal, if I can obviously explain the position from my client's part. I think that's right, but again, I mean, from our part, the client was a litigant in person. So obviously, was it somewhat of a disadvantage from a legal point of view? Because certainly he issued the claim. We've very recently only just come on board as legal representatives. Now, Your Honor, I think you're quite right. It can't just be a sort of a carte blanche, amendment. I think certainly it would make sense to have some sort of staged approach where each part, well, certainly the defendant was to provide their proposed amendments, and then obviously we would look at that. Because if it goes too far beyond what is already in the pleadings, then obviously that's a sort of cherry, isn't it?
I'll hear from Mr. Bijmal again. What I'm inclined to say is that you've each given yourselves a reasonable amount of time. I think the first amendments aren't going to come through until the 19th of December, which is still, well, it's more than a month away. And what I'm inclined to do, I think, is to include a provision within the order that if either party contends that amendments should not be made, then they're to notify the other party within, I don't know, 7 or 14 days of the dates being served, and the matter will come back before the court. That's what I'm inclined to do. As I say, I'm constitutionally a little nervous about giving complete leave to amend in blank. Does that give rise to any difficulties so far as you're concerned?
Not from my side. I think that seems sensible. Yeah.
That's fine for us as well. Just to also point out that the intention is not to go above and beyond, and also during the correspondence between us and the other side, there were some lines established, and that we exchanged emails about broad categories of what are we planning to do. So I think we've drawn some lines which shouldn't be problematic.
It sounds to me as if both of you, if I may say so, have approached this very sensibly. It's just that sometimes, with the best will in the world, one finds that when the amendments are actually made, there are particular problems, and if there are, I want to keep control of it. That's the first point I wanted to ask about. Second, you've each produced a list of issues, but your list of issues sadly don't completely tie up. I'm not inclined to sort that out or try and sort it out now. What I think I am inclined to do is to say that when the pleadings have been completed with all the amendments, the two of you try and produce a unified list of issues rather than separate lists of issues. And if there are any differences between the parties, you identify what's agreed and what's not agreed, and provide reasons for the differences. I mean, just in relation to lists of issues, I mean, you gentlemen are both pretty experienced in this field, but on the whole, if one party says it's an issue and the other one doesn't, then it's likely to be an issue unless it's omitted or it doesn't arise on the pleadings or some other matter. So I'm sure you can sort it out, but it's not particularly helpful to have two separate competing lists of issues for obvious reasons. So what I'll do is I'll include a provision to the effect that let me just get the order up. Hang on a second. I've lost it. Just give me 2 seconds.
Yeah, I think it's on page 93.
Yeah, thank you. Yeah. So just dealing with the provisions we've made, if we go back to the beginning, So I think what we'll do is that in paragraph 1 of the order, we'll say subject to the right of the opposing party to object to any amendments made within 14 days of service. And then we'll have 1, the defendant shall file and serve, 2, the claimant shall file and serve, and 3, the defendant shall file and serve its amended version of the reply to the amended defence counterclaim by no later than 4 p.m. on the 30th of January 2026. So those first 3 will all be sub-paragraphs to that. Is that acceptable to you both?
Yes.
Yes.
And then we'll add in what I think will be a new substantive paragraph 2, which is, so that's going to be done by the 30th of January. The parties shall by 13th February 2026, 2 weeks after the issues, seek to agree a unified list of issues. And in the event that agreement cannot be made, shall submit the matter to the court and with reasons for differences.
Yes.
As you've done the draft of this, could I ask the 2 of you to amend this and then submit it to the registry after the hearing? Will that be satisfactory?
Yes. Yeah.
And then you've got standard production of documents, which is no difficulty with objections and so forth. And then that leaves to witness statements 1st of May. Now, what are the expert reports? What fields are the experts likely to be involved in?
From our side, we still haven't decided for sure whether we will have an expert, but if we do, it might be about the defective goods. So there might be some opinions on the quality of the products, or some of them that were delivered.
And what field is that going to be in? Is that going to be in, I mean, there's this argument about styles and so forth. Is that going to be an expert in the industry, or what's it going to be, or don't you know?
We don't expect to have an expert opinion on that, because we believe that this is a legal interpretational argument of with regards to the contract. So possibly we might have an expert give views on the quality issues and on pricing, in terms of because we believe that there are certain uplifts placed on the pricing, and we might have some expert give us an opinion about whether that's reasonable within the industry.
Mr. Whitehead?
Yes, so from our side, I understand that an expert report has actually already been filed, but it would be a forensic accountant.
So sorry. That was the one which was filed with the claim.
I believe so. Yeah. But for this stage, it would be a forensic accountant. But again, in terms of the value of the claim, proportionality, whether or not experts are specifically needed, I would certainly question that. And in any event, I think the parties, we would need to file an application under DOC court procedure for expert reports, as far as I understand.
Well, I agree. I mean, it seems to me that at the moment, paragraph 14 says subject to the court permitting the submission of expert evidence, which is, I mean, it seems to me that after you, when are you going to know whether either of you want to put in expert evidence, and in what field? You're going to know it. You're going to know it probably at the latest by the time you've had witness statements, but possibly before that, aren't you?
Correct. Yeah. And I think we've sort of kept it deliberately open by ensuring that's subject to court permitting submission. So we.
Well, sorry, you finish.
No, I think as I was saying, I think ultimately, if a party did want expert evidence, they would have to file an application in any event.
Right.
Yeah.
Right. I think that what we'll do is we'll introduce. I'm sorry, I've got the numbering lost on this, but before the existing paragraph 14, we'll say, I think we'll introduce him. If either party wishes to rely upon expert evidence, they shall identify to the other party the proposed scope of the expert evidence and the identity of the proposed expert, and make an application for receiving such expert evidence. And then I think I just want a date to put that in. Would it make sense to have that by the same time as witness statements, 22nd of May?
Yeah, I think that's fine.
Mr. Benjamin?
Yes, that works for us.
Okay. And then I think then 14, 15 and 16 can all go ahead. Yeah, and that's leading to a trial in September of 2026. Yeah, well, that seems to me, with those amendments, to be satisfactory. Do either of you have any other points that you want to raise now?
Nothing from our side.
No, it's same, Your Honour.
Good. Well, thank you very much for your cooperation in relation to it. Could I please ask this? Will one of you please, ideally today, well, perhaps the claimant, you'll take carriage of the order. Can you make the amendments that I've suggested, get them agreed with Mr. Benjamin, and get them back to the registry? If there's any kind of dispute about what the order is, then can you make sure you get it to me before I've forgotten all about the case? So I can make the required order, but ideally today, and if not today, tomorrow, and then we'll get the order up.
Yeah, we'll do that today, Your Excellency. Yeah.
Thank you very much.
Thank you very much.
Anything else?
Not from us.
That's it.
Good. Well, thank you both very much indeed. Thank you.
Thank you.